Mr. Knox.
My Lords, I'm conscious of the time, so can I perhaps just take parts of my cases read which deal with what was found at first instance in the Court of Appeal and just go straight to Suraj?
Yes.
My Lords, my Lady, what we say at the starting point is Section 13 of the Constitution, which is at 1292. Perhaps I should have said the starting point is Section 5, which is save as expressly provided in this chapter, and then you get to Section 13. Section 13 here is clearly allowing for a specific derogation by Parliament in normal circumstances, as opposed to emergencies. Specific, and it's saying, well, you can see what it says, you can pass such legislation even though inconsistent with 4 and 5, and if any such act does declare, it shall have effect accordingly, unless it is shown not to be reasonably justifiable. So 2 preconditions. One is the supermajority, and the other is it's got to survive an attack on the footing that it's still not reasonably justifiable. And importantly, in a society that has a proper respect for the rights and freedoms of the individual, which I note parenthetically is slightly different, and the words have obviously been carefully chosen, from what you see in Section 7.3 at 1290, which allows for infringing legislation to be passed in an emergency, as long as it is save insofar as its provisions may be shown not to be reasonably justifiable for the purpose of dealing with the situation that exists during that period. So, my Lords, one starts from a position. This is a carefully thought out provision. And, my Lords, the important point is it gives even greater protection to the fundamental rights and freedoms than the ECHR does, or indeed the other constitutions throughout the Caribbean. There's no equivalent to Section 13 as far as we're aware. So it's of itself. Secondly, my Lords, and importantly, it was passed against the background of Hines, which was decided in 1975, and one can perhaps most speedily pick up Hines, the relevant bit of Hines, and Barry Francis, the case I'm going to come to in a moment, at page 2710. This is the judgment of the minority of the Court of Appeal in Barry Francis, which the Chief Justice Archie, and Mr. Justice of Appeal Jamadar gave a long, but we say powerful dissent, saying they just didn't think Francis was right. But can I take you for the moment to 2709? First, and just ask you to read to yourself paragraph 62. This is the background to the Constitution.
And is this in the majority or the minority?
This is the minority. But they're explaining why it is you have to take into account Trinidad and Tobago's multi-ethnic makeup, and undoubtedly the case, and my Lords, you'll be familiar, it's a commonplace. There's certainly was a divide between the African and the Indian populations, and politics tended to turn on that. So there's very good reason for the notion of a supermajority when you have what you might call quite a racially divided country, which can get a bare majority in. It's a good idea to have some super protection to stop the bare majority getting their way the whole time. So what you see in paragraph 62 is the minority's explanation as to the background, or one of the features of the background in the Constitution. Now, Hines, you can see, referred to in Barry Francis, Well, it's referred to in Barry Francis, but one could also go to Hines itself at 2930. Begins at 2911, and the issue in this case was whether it's essentially a court or a reviewing court which did not consist entirely of High Court judges but had power to pass sentence, whether that particular reviewing body was lawfully constituted under the Constitution. The relevant passage in Lord Diplock's speech, which in my submission has been regarded as a locus classicus for a very long time, and one can infer would have been in the minds of the framers of the Constitution, albeit this is Jamaica, not Trinidad. It's at 2930, and it's the passage which you see in beginning at C to G, especially F to G. This is, in my submission, until Suraj came along, this was textbook stuff. No one doubted it. And it's the bit you'll have seen, you'll have picked up. So in deciding whether any provisions of a law passed by Parliament of Jamaica as an ordinary law are inconsistent with the Constitution, neither the courts of Jamaica nor their lordships are concerned with the propriety or expediency of the law impugned. They are concerned solely with whether those provisions, however reasonably expedient, are of such a character that they conflict with an entrenched provision of the Constitution, and so can be validly passed only after the Constitution has been amended, and so forth, well, in this case by Section 13. So the expediency of ordinary legislation is not a relevant consideration in considering whether or not an entrenched provision can be departed from. We say there's no reason why that shouldn't apply in Trinidad when you've actually got Section 13 sitting there, explaining how you are to pass infringing legislation. My Lords, if I may go back to Francis at 271.
I'm sorry, just before you do.
Yes, my Lord.
I haven't read the whole of this judgment, but at the moment
Yes.
I'm not sure what the sentence beginning "so" at F
Yes.
sounds as if it's logically derived from what precedes it.
Yes.
I don't at the moment see what the connection is between what's said in that sentence and what's said in the rest of the paragraph.
Well, my Lords, as I apprehend, what he's saying is it may be an inconvenient result, because it may not have been such a bad idea for ordinary legislation to have a reviewing body of which did not consist of judges reviewing or passing sentence. And he's saying, well, but there is an entrenched way. In other words, the powers of the judiciary are simply set out in the Constitution itself, and only judges can fulfill sentencing functions appointed in accordance with the usual provisions under the Constitution. As only judges appointed in accordance with provisions of the Constitution can act as High Court judges or make sentences, it follows that the reviewing body which had been set up, which did not consist entirely of High Court judges, simply had no power to do what they were doing. And then he's saying, you might think it would be expedient and convenient if it did, but that's irrelevant.
Yes, so if that's so, then he's not actually talking about what we were talking about earlier at all.
Well, in my submission, not exactly. I agree.
There's a sense in which, when this court deals with human rights cases, we're not concerned with the propriety or expediency. I mean, we're not judges of that.
No. But what's being suggested, as I understand it, is that if legislation is expedient and pursues and has propriety, and in other words, pursues a legitimate aim, it follows from that ordinary legislation can infringe or abridge or derogate from fundamental rights and freedoms. And we say that's just wrong. We say, by parallel reasoning, I accept, my lords, it's not identical, but we say the general understanding is that entrenched provisions, and the fundamental rights and freedoms are entrenched provisions on the face of it, can only be interfered with in accordance with the methods set out in the Constitution, and not implicitly by ordinary legislation being passed which pursues a legitimate aim and is proportionate.
I mean, your submission is the language in which you couch it, sort of is apt to carry you over some thin ice. When you're talking about infringing it, you are not saying that the rights are unqualified and that anything that impinges on them is an infringement.
No, I'm not saying that. I accept they are qualified. They never were absolute. They were always subject to qualifications, and I would accept too that, and I'll come to this, but the qualifications which are of the sort, or of an ordinary sort, and of the sort which one might have anticipated when the Constitution was passed, then there's no need for extraordinary legislation. It's when that you are doing something extraordinary you need special legislation.
I have to say, I read this passage, and you're right, it is a familiar passage, as Lord Diplock simply saying, if you've got a constitution, which you don't have in the Westminster model, then the test for the court is a legal one, is the relevant provision of legislation in conflict with an entrenched provision of the Constitution.
Yes.
But I don't see how that helps us with the Suraj question, because it's being argued that in relation to whether there is a conflict with an entrenched provision, since the relevant rights are qualified rights, the way you deal with the operation of the qualification is by application of the familiar test, which was what was applied in Suraj.
Well, my lords, if I may say, I've given you part of my answer already. Right. I'm conscious of the time, my lords. Anyway, I say the purpose of Section 13 is to give greater protection than the ECHR was to give. That's the whole point. And it's very important to note, my lords, that unlike other Caribbean constitutions, this constitution follows the Canadian model. I don't think the Canadian model had an equivalent to Section 13. I therefore submit it is wrong to assume that the intention of the framers was somehow to repeat or to reenact or to, so to speak, incorporate by reference what you see in the articles in the ECHR. They could very easily have done exactly what the other Caribbean constitutions do, which is effectively to provide for rights which could be derogated from, as long as it's proportionate and reasonable, by ordinary legislation. They've not done that. And I submit one cannot really get out of that point with great respect. There has to be some real purpose given to Section 13. Thirdly, my lords, I submit for the reasons set out in the passage I showed you from Barry Francis, there was good reason for this concern to have what you might call supermajority, because of the very diverse community and, as the Court of Appeal or the minority put it, the low trust in politicians, which the passage I took you to in paragraph 62. The next point I make, my lord, is this. There would be, in my submission, strange consequences if the, what you might call, proportionality test were to apply, even in ordinary legislation. Say, for the sake of example, ordinary legislation effected a complete abrogation. All right, let's just say you can't go out of your house for the next 2 months. Well, I'd say, well, it's proportionate, you know, it's very proportionate. We're facing a great crisis. In my submission, it is odd to suppose that the intention of the Constitution was that that could be passed by ordinary legislation, simply on the footing it was, the courts would then decide whether it was legitimate or not, rather than Parliament. Because what essentially the argument that's being put to me involves is that, well, the courts can always, so to speak, supervise the reasonableness or otherwise of the legislation. My submission is no, the idea of this Constitution is Parliament does, in the first instance, hence Section 13. And I do submit it would be odd for there to be a complete abrogation passed by ordinary legislation, and the average citizen would just have to take the risk of litigation. And, my lords, we say with respect, we can't do better than what is said by the minority in Francis at page 2731, paragraph 97.
Which was the page again? Sorry.
2731, I think. I hope I've got the right page. Paragraph 97. Yes, para 97. Miles, can I just ask you to read that yourself? My lord, that's right. It puts our position.
Do they deal with the application of the rights not to, in relation to legislation, but in relation to executive action?
I'm not sure they do, my lords, as such. In this, this is a case
So
by
how
sentence.
do you say one is to deal with executive action, which might be said to be in breach of the fundamental rights?
Well, in this case, this is that they are dealing with legislation which is in breach of the fundamental, because that was the issue, yes. Well, my lords, we would say the position is a fortiori. If the legislature is prevented from passing regulations on a proper construction of the Constitution, it would be surprising if the executive still retains a power to do, or a different, what I call standard, applies to the executive. And in this case, we're talking, of course, about regulations passed under delegated legislation.
Right. So I'm just trying to see where this argument leads. Suppose a power of arrest, a policeman applies that excessively. So it's there in legislation, but the policeman, it's argued, has acted in breach of fundamental rights when they effect an arrest for some particular reason. How does one test whether that claim is made out?
Well, my lords, if it's a breach of your, if you've been wrongfully arrested, it might be said, well, you've just been wrongfully arrested. I mean, that would be the breach of your right not to be deprived of your liberty without due cause. I mean,
right, but I mean, if you've got, the policeman's got a power of arrest, and it's said that he's exercising it in an excessive way in the particular circumstances of the case.
Well, yes.
How does one address that sort of case?
Well, my lord, my answer to that, I'm afraid my simple answer to that would be, well, there's a tort at common law if that's the case. It wouldn't necessarily, it may also amount to a breach of the constitutional rights because he is going further than is allowed by the Constitution.
All right, take another case. I mean, a case where social workers think a child's at risk in their family, and they've got powers under legislation to take action if they believe that something is going wrong with the child, and they take the child into care.
Yes.
And then it's said, well, that's a breach of the rights to respect for private and family life because of the way they did it, or they've exercised their powers in an excessive way. Therefore, breach of the constitutional right. How should the court address that sort of case?
In my submission, one might start. Well, first of all, you have to look at the legislation under which it was done, of course.
Right.
And you have to say, well, and then the question would be, was that legislation within did it pass muster against the fundamental rights and freedoms test?
Right.
But if, let us say, this would all have to be done on a case-by-case basis. And I said, well, this is a fairly typical piece of legislation which was of the type which you would expect to have been passed back in 1976, then you don't require special legislation for that. And my lord, I would like, if I may, just
on the taking the child into care. I mean, typically there'll be general powers for social workers in that sort of situation. I'm afraid I don't know the precise position in Trinidad and Tobago. But what is then said is that in the particular circumstances of the case, the social workers have behaved in an excessive way. And you get a lot of cases alleging breach of Article 8 in this jurisdiction by reference not to whether there was a power under the primary legislation, there is, but as to the way in which the particular public officials have acted.
Well, my lord, there is an equivalent there is respect for private life, I seem to remember, as one of the other rights. I would
Yes,
say, well,
absolutely.
yeah, in that case, I would say if they've used their powers excessively, then just like a police officer using his powers excessively and therefore wrongfully, there would on the face of it be a breach of the Constitution, of the fundamental right.
But how does one tell whether it's excessive or not? Because under Article 8, one would go say, are they acting for a legitimate purpose in a proportionate way?
Well, that would be because if they were acting in accordance with the regulation or statute in a proportionate way, then I would say there'd be no objection to that at all, because the statute on the proper construction necessarily authorises people to do things in a proper and proportionate way, but not in a disproportionate or excessive way.
So
that
it would just be an
answer.
ultra vires act by
Unauthorised.
an unauthorised ultra vires act
Without any proper authority.
Right.
We are going to have to be self-disciplined and
Yes.
make your submissions.
I'm terribly sorry, my lord. I can't, as you probably know, I find it difficult not to answer a question. But in any event, we say on a proper reading, Surat, so we say the proper analysis is set out at Francis, at 2272, para 76, and footnote 64. And in particular, we say 76 subparagraph E, I think it is. E and G, and then footnote 64. We refer to these in our written case, but we say the proper approach is 76 at 2272 to 2273 and 2274. When you're talking about legislation, and my lords, I do emphasise we're talking here about what powers are there to pass legislation at certain times. And it's quite dense stuff, my lord, but it puts in printed words what I'm trying to say, namely you look at the type of restrictions that existed at the time. Developments or natural and ordinary developments from those do not require special legislation, but extraordinary ones do. We say that fits the scheme with Section 13I. And we also say, my lord, it fits the scheme of the emergency powers. My lords, can I we deal with Surat, I'm conscious of the time, my lords. Surat.
Yes, and we've yet to hear from Mr. Ramlogan.
Yes, exactly. My lords, we deal with Surat, and what we say the proper construction is, in our written case, it starts at 4388, para 52. Actually, we deal. It starts at 514387, where we describe the facts of Surat, which was about the introduction of equalities legislation, essentially. And the trouble is the legislation was never brought into effect. And so a complaint was made, but the Privy Council and the relevant rights were right to freedom of thought and expression. And the Court of Appeal in Trinidad said this legislation, amongst other things, had to be passed by special legislation under Section 13. And then, and therefore, it was held that the Act infringed the it was held, therefore, the Act that was supposed to be brought in infringed the fundamental rights and freedoms. Therefore, the claimants who were trying to get the Act brought into effect had no case. The matter goes up to Privy Council, and the Privy Council says, no, the Act does not infringe the fundamental rights and freedoms. And one can take that on from paragraph 52. And Lord Bingham says he doesn't really want to express a view on the point, but he does make the point that if you look at the legislation in question, it's not inconsistent with the general tenor of the opening words of the Constitution. That's paragraph 53 and 54. So he doesn't express a view on the point, but says he doesn't think it would be inconsistent. But, my lords, can I ask you to look at what Lady Hale said at page 4389? I just want to emphasise a point on that.
Page.
4389 in our written case, where we cite Lady Hale's speech. And my lords, what we say is that on the facts, Lady Hale explains this by saying, well, it's not every impingement, we accept that, but the important point is Section 7 does impinge upon freedom of expression, but arguably goes no further in doing so than existing law. If it does go further, by including gender as well as racial or religious hatred, it's merely bringing the law into conformity with all modern human rights instruments. Section 1718 impinges upon freedom of contract, but in ways which are now so common in the common law world, it can hardly be argued they're not proportionate to the legitimate aim they pursue. So we're talking here on the facts, and Lady Hale is justifying this by saying, well, these are not great big impingements. They're normal, and they're not major, they're not large. I understand the points made to you, well, how does one measure large and normal and things like that? But there is a way of measuring the line, respectfully. And I say that's the ratio of the decision. My lords, we do set out in, I think it's paragraph 69 at 4393, why we say if Suraj goes further than what I've suggested, it is wrong. And my lords, it's 69 subparagraphs 1 to 5, and it sets out there in writing some of the things I've said already. And we say the proper approach and the logical approach is what is said by Lord Dyson in Appellant 3601, where he's talking about what amounts to infringement of the right to enjoyment of property, 3601 of the bundle.
That last page number?
3601. This is a case of some taxi drivers who there'd been assurances they'd be able to operate from a particular taxi rank, and then regulations were passed which deprived them of that ability. And a complaint was brought that, amongst other things, that amounted to a breach of their legitimate expectation and their right to enjoyment of property. You see that at 3601, at para 23, where they are talking about here what amounts to an infringement of your right to enjoyment of property. 23.
And you say that this certain level of significance or general regulatory laws, looking at Lord Hoffman quoted there, are all different ways of saying this ordinary versus extraordinary, minor or major, all the same, expressing the same distinction in effect.
I thought this is Lord Dyson effectively applying the jurisprudence of the ECHR and saying, in the regulation of use of property case, you have to get beyond a certain level before it is treated as Well, as an infringement in the first place, certainly before it gets to be a deprivation.
Well, my lord, I accept he's drawing on, of course he's drawing on the tractorial case, but we say this is the correct approach. There has to be a level of significance in order, because of course, my lords, I'm arguing at the moment, I'm saying basically you have to resort to the emergency powers of Section 13, but I do accept there can be exceptions where you don't have to use those special powers. And that's what we say, and we say it's this type of legislation. You say, well, that's not particularly significant. Or in the Lady Hale case, it's maybe it departs a little bit more or whatever. We say that's the limit. But there's no authority for saying that you can have a wholesale abrogation or major abridgments and by ordinary legislation and justify them by reference.
This form of words, if it must attain a certain level of significance, is it's a standard form of words in Strasbourg jurisprudence. You find it in Article 8, for example, in the case law. And it's really the equivalent of a de minimis test.
Well, my lords, whether it's that or not, but that's my lords, that's our case. Can I just mention one other thing? I've made the point already. We say when you are assessing the scope of the fundamental rights and freedoms that are protected, you are looking at those that are traditionally protected. So, for instance, my learned friend refers to a religious a case from Canada, in which it was held that where the Canadian Constitution at that time had a very similar provision preserving all those rights and freedoms that have existed and shall continue to exist. And it was held that effectively a Sunday trading law was not inconsistent with the Constitution because it was essentially such a well-established practice. And we would accept that laws which on at first sight might be said to derogate from fundamental rights and freedoms, if they're well established, long part of the common law, then of course there is no problem in saying that they continue, that you don't have a wholesale change, and that those laws are not to be treated as infringing the fundamental rights and freedoms in place when the Constitution came into effect. My lords, I can see the time. I'm very conscious of it. As far as the rest of our case, the existing laws point we set out in our written case, we just say the regulations just aren't an existing law in accordance with the definition, and we also say, even if they are inconsistent with sections 7 to 12, which provide for how you pass inconsistent legislation. And as to relief, my lords, you'll see what we say in our case. We essentially say it's not for you at the moment to do anything more, if we're right, than to give a declaration. And we suggest various alternatives to the declaration. My lord, I'm conscious I've gone on beyond my time. I don't know if Mr. Ram-Logan wants to say just a few brief words on the sovereign democratic state point. It's in our written case, but I shall leave that to him.
Thank you very much, Mr. Knox. Mr. Ram-Logan.
My lord, I thank you very much. My lord, the sovereign democratic state point, in a nutshell, is this. Prior to independence, when this ordinance was passed in 1940, we were at the time a British colony, and the Legislative Council was in existence, and the British Imperial Parliament would have passed that ordinance. And what we say, my lord, is at that time Parliament was supreme, and that there was no concept of a participatory democracy for the colony. And there was no concept of governance with the consent of the people. And what we say, my lord, is that when we attained independence and the 1962 Constitution came into being, it ushered in a new era, which was based on the enshrined concept of participatory democracy and governance by the will of the people. Section 5 of that 1962 Constitution, therefore, which is the analog to Section 13 now, spoke to any act of Parliament that is inconsistent with the fundamental rights provisions, having to be passed with a special majority and being subject to the reasonable justification test. Now, the use of the word act is specific, and it's repeated in Section 13. It was in Section 5 in the 1962 Constitution. And my lord, we say that, look, that the use of the word act was very specific. It is clear that what was contemplated is that henceforth, if there was going to be a law that would be inconsistent or interfere with fundamental rights, that should be done by an act of Parliament and not necessarily by subsidiary legislation in the wholesale manner as occurred here. I pause to make good the point, my Lord, that this is the first time the board is considering this unique problem. In all of the other cases, like Matthews and so on, where this existing law point was taken, it dealt with a law that was already in existence and made. Here, what we're confronted with is a law that was not in fact made that predated the Constitution. The law is made temporarily in today's present time. And what was preserved would have been a law-making power, not a law. The law we are dealing with is made today, in present time, and what was preserved would have been the law-making power, which in 1965, after the Independence Constitution came into existence in 1962, the law was amended to transfer the lawmaking power from the board of 9 to a single minister in the executive. And we say, my Lord, that any pre-constitution lawmaking power that would have been conferred by the Imperial Parliament, it must now be read subject to and in accordance with the provisions of the Constitution that came into existence, because it made the Constitution supreme and not Parliament. And in a constitutional democracy where the Constitution is supreme, Parliament itself and all lawmaking power was now subject to the constitutional provisions, which included a 3/5 majority and the reasonable justification. So the issue is, how did the Constitution impact on lawmaking powers that predated the Constitution? And the simple submission is that Parliament must be presumed to legislate consistent with the Constitution, and even the amendment in 1965 to transfer the power from a board of 9 to a single minister in the executive, that too must be read as being an amendment that is consistent with and subject to the Constitution. In 1976, the Republican Constitution introduced the provision that that we are a sovereign democratic state. That was not in the Independence Constitution, but my Lord, the significance of that really is that it enshrines the deep structure of the Constitution, which encompasses the rule of law and the separation of powers. My Lord, you will see this in the judgment of Justice Jamada in the Caribbean Court of Justice at page 1890 to 1892, where he gives a wonderful and illuminating exposition on the deep structure of the Constitution and it being born out of the struggle of a people that attained independence and then Republican status. I commend that passage. In the interest of time, I will not read it. But my Lord, what it shows is that it would be wrong to take the lawmaking power that predated the Constitution and ignore the express provisions of the revolutionary impact, which changed the legal paradigm, changed the process by which laws can be made which are in conflict with the constitutional rights, and to ignore those provisions and simply say that the minister could make powers without reference to duration, without reference to proportionality and so on. He can make those laws because the lawmaking power, which was given to the board of 9 before the Constitution came in existence, and in 65 by amendment transferred to the minister, that can be looked at in a vacuum without reference to the fact that the Constitution bites when it comes into existence and makes it subject to the Constitution itself. And my Lord, in effect, my Lord, what we're saying is that in Ex parte Sims at page 4056, what Lord Huffman said is that the principle of legality means that Parliament must squarely confront the political cost of making laws that interfere with fundamental rights. If the government, if the executive can use a single minister to make these laws that you can have a wholesale deprivation of fundamental rights without reference to Parliament, without parliamentary scrutiny, input, oversight, or involvement, then no government will engage Parliament, and there'll be no, you can avoid the political cost referred to in ex parte sims by simply doing it through a single member of the executive. And we say that when the structure, the deep structure of the Constitution is taken into account, the Act of Parliament referred to in Section 13 and Section 5 prior to that, the Act of Parliament, the core constitutional duty of Parliament to pass laws that are in conflict with the constitutional rights which are enshrined in the Constitution, we say that that cannot be delegated, as it were, to a single minister of government, because it would render nugatory the express and clear words of Section 13. So we say the amendment in 1965 has to be read subject to Section 13. The power given to the minister to make laws in 1965
Yes, yes. We'll contact our IT people, but I won't adjourn immediately, because it's conceivable the problem might be at Mr. Ramlogan's end, and no doubt that he'll be having somebody look at it there.
Well, he's probably worked out, but we'll send him a message anyway. Yes.
Yes, Mr. Ramlogan, can you hear me?
I'm hearing you, my lord, yes. Can you hear me?
Yes, we lost you just now for about 2 or 3 minutes.
Okay, I'm sorry, my lord. I apologize.
No, it's not your fault.
You've been saying that the amendment in 1965 replacing the board with the minister had to be read subject to the fundamental rights or something to that effect.
Yes, well, what I'm saying is in 1965, when that power was transferred from a board of 9 into the hands of a single member of the executive, with the Constitution, 3 years after the Constitution came into existence in 1962, that lawmaking power which was being given to the minister has to be read subject to and in accordance with the provisions of the Constitution, namely Section 5, which is the predecessor to Section 13, and that it would be wrong, it would not be a constitutionally compliant interpretation consistent with the structure of the Constitution to say that it could give that power to the minister in a way that can bypass or override Parliament, as the case may be. My lords, this is not, as I indicated at the onset, a case like the death penalty case or any other case. In those cases, the laws that was the subject of judicial consideration already existed. Here, the law did not yet. The law came into existence after the 1976 Constitution. The lawmaking power given to the minister might have predated the 76 Constitution, but it certainly did not predate the 1962 Constitution, because it was given to the minister in 1965. We say when one, to reconcile that in a constitutionally compliant manner with the deep structure of the Constitution, one must read it against the backdrop of Section 5, which would mean that the minister can pass such regulations as may not be in conflict with or may not deprive someone of their fundamental rights, but it does not confer upon him a power post the 1962 Constitution to usurp the core constitutional function of the legislature, which was to pass laws that can deprive people of fundamental rights. That would be to sign a legislative blank check to give to a single member of the executive, and that we say would be contrary to the separation of powers, the deep structure, and the rule of law.
Yes. So am I understanding you correctly, Mr. Ramlogan? Is your point that the amended version of sections 103 and 105, which give, or is it 103, which gives power to the minister, was not an existing law in 1962?
Correct.
Yeah.
Because it was done in 1965, my lord.
Yeah,
and it's
I understand.
And because a citizen's fundamental rights were not in jeopardy of being taken away by a single member of the executive prior to 1962.
Yeah.
It was a board that had that power, and a board of 9. But the law changed 3 years after the Independence Constitution in 1965. That changed, and that change, we say, has to be read in a manner that is subject to and in accordance with the Constitution, which changed the legal paradigm. It was a revolutionary change to the process by which the laws can be made. And this case is about process. No one is challenging the vires or the proportionality of the law itself. What we are on is the process by which one can make laws that can deprive a citizen of their fundamental rights. And the question here is, can a single member of the executive take away a citizen's fundamental rights without reference to Parliament for an unlimited duration and for reasons that are far and wide? And we say, my lord, that offense, such an interpretation will be offensive to the concept of rule of law. It is not possible to reconcile it with the deep structure of the Constitution expounded by Justice Jamada in the case we have referred you to. And we say that it offends the principle of the rule of law, because, my lord, a minister may not necessarily be elected. He can be appointed through the Senate. So you can have an unelected member having this entire reservoir of power, which could very well be a non-delegable core legislative duty of the Parliament in light of Section 13, using the word act and not, regulation or subsidiary legislation, but it uses the act of Parliament.
So Mr. Ramlogan, am I right in thinking that the minister, it would be normal for the minister, if he's not a member of the lower house, he would be a member of the upper house?
Yes, my lord. But the point is, he would not be an elected member.
No.
And it just strikes at the heart of the concept of a participatory constitutional democracy.
And is the minister accountable to Parliament?
He would be, yes, my lord. He would be, yes.
Thank you.
He would be, yes.
So what law, Mr. Ramlogan, what law then are you saying was actually contrary to the Constitution? You seem now to be challenging the transfer from the 9-member board to the minister as a single person. But are you saying that was unconstitutional, or are you saying that that transfer of power impliedly then restricted the kinds of enactment, to use a neutral term, that could be made using the powers that would have been fine if it had been the board doing it, but now is not fine because it's a single, potentially unelected minister to do it? Is that the thrust of it?
It's a bit of the latter, my lady, but I won't put it quite that way. What I suggest is this: the amendment created, to the extent that the amendment altered the substantive law from the ordinance by giving the minister a power to make regulations, which hitherto was not the law. So this is an amendment which creates a new law. It gives the minister the power to make regulations under the ordinance. That lawmaking power given to the minister, because the amendment came 3 years after the Independence Constitution, has to be interpreted in a constitutionally compliant manner, and that means that it cannot be interpreted as that the newly independent Parliament, 3 years into the life of its constitution, could be giving the minister the right to pass laws that can deprive people of fundamental rights, without reference to parliamentary scrutiny, input, or approval in any form or fashion. That such a contention will fly in the face of the established canons of construction that says that when fundamental rights can be altered, you need clear and express words, and you can't imply it, and you can't infer it. And that would be an inference, we say, post the constitutional order ushered in by the Independence Constitution that simply can't be supported. So what I say, my lady, is not that it was wrong to give it to the minister, but that the Parliament could have given it to the minister. It did give it to the minister, but Parliament must be presumed to be legislating in a manner that is consistent with its own constitution. And for it to legislate in a manner that is consistent with and in conformity with the Constitution, the power given to the minister could never be a power to bypass Parliament and take away in a wholesale manner an entire country's fundamental rights without reference to Parliament, without reference to duration, and etc. That just would be offensive to the very basic an essential sacred structure of the Constitution for a people that struggled to gain independence, so that we will move to a situation where there was governance with the consent of the people, in accordance with the will of the people, and in accordance with the Constitution, which became the supreme law, to which Parliament and the executive and the judiciary were all subject to. So, Melody, that's what we say. I say the Court of Appeal, if I take you quickly to page 56, in the first supplemental bundle.
Yes, just do be, Mr. Ramlogan, you will have to be quick because I'm going to have to let the respondents have their chance in about 5 minutes.
I apologize. I can give you the page reference, my lord. I'd ask the court to look at the judgment of Achille Charles, which is in the first supplemental bundle. It's a page, I want you to look at page 56 to page 61. 56 to 61 in the first supplemental bundle, paragraphs 62, 69, and 75. Paragraphs 62, 69, and 75. And what the Court of Appeal said, my lord, is that they recognize the principle of separation of powers as being implicit in the structure of the Constitution, and they recognize in that case that it is relevant to determining the constitutionality of a law. Here, we are not determining the constitutionality of the law per se. We will get to that. But before that, we are determining, the question is, how does one interpret the lawmaking power given in 1965 to the minister in light of the basic and essential structure of the Constitution, which enshrines the rule of law and the separation of powers. Lord, the Court of Appeal in that Achille Charles judgment said that they preferred the minority judgment of the court in Barry Francis. That is a powerful, erudite, and respectfully an illuminating dissent, which microanalyzes Lady Hale's judgment in Surat. And my lord, it is a source of immense controversy and contention in Trinidad. We now have 2 Court of Appeal judgments, the latter one being in Achille Charles, where the Court of Appeal unanimously said that they prefer the minority judgment, but they are bound by the majority judgment, and it's a matter for the board to look at. My lord, speaking for myself, I see that the analysis of the Honorable Chief Justice and Justice of Appeal Jamada in that minority judgment is one we seek to vindicate, and one with which we agree as being plainly right, because the 3-step test we applied in this country prior to Surat was, the first question is the law inconsistent with fundamental rights? The word inconsistent is what is used in the Constitution. That's the first question. If the answer is yes, you go to the second question. Do you have a special majority? And it's only if you clear that second hurdle that we get to the third hurdle. Well, is it reasonably justifiable in a democratic society with respect for fundamental rights? And the minority has said that the board was wrong respectfully to conflate the first test, which deals with inconsistency, with stage 3 by extrapolating the proportionality test into the inconsistency test at hurdle number 1. But my lord, the spanner in the works here is that the special majority provision, which doesn't exist in any other constitution that we've been able to find in the world. And that special majority, which are 3/5 in both houses of parliament, was an important constitutional safeguard that came at the Pact of Independence, negotiated by the country's first prime minister and leader of the opposition, and it was negotiated on special terms because, as alluded by my learned friend, Mr. Knox, because of the racial divisions and the composition of the society. And it came at a time when slavery had been abolished, indentureship was introduced, and you had after 1836, with the abolition of slavery, you had a situation where indentureship came into existence, and there were people flung together in an emergent society. So, my lord, it is in those circumstances I say that Justice Yamada in the Belize case and in the Guyana case in the Caribbean Court of Justice, both of which we have referred to, it's number 40 in the joint bundle, the Guyanese case, and the Belize case is one we referred to before. We say that the socio-political struggle and the culture of the country, which led to these unique provisions, simply cannot be ignored. And however you twist it and dissect it, at the end of the day, what Suraj says is, if the law is proportionate, then you can pass it with a simple majority. And what is lost in that, which we must confront, is what then do we say about this special majority provision? When does it apply? How does it come into play? And when does it come into play?
Well, Mr. Ramlogan, I'm sorry to interrupt you, but I'm going to have to stop you there. You and Mr. Knox have been addressing us now for 3 hours,
Indeed.
and I have to allow the respondents an opportunity to reply. So thank you very much indeed.
Thank you very much.
Unless there are any questions for you.
Sure.
Well, thank you very much, Mr. Ramlogan.
Much obliged, sir. Thank you very much.
Mr. Rowe.
My lord, the scheme of our case, as your lordships will have gathered, I expect from our written case, is essentially this. First of all, we submit that one doesn't get to the question of whether the regulations under challenge abrogate, abridge or infringe the rights and freedoms that are recognised and declared in Section 4 of the Constitution, because of the structure of the Constitution and because of Section 6, which deals expressly with the consequences of something being an existing law. But in any event, we say that even if it weren't, even if the Constitution were different, even if there were no existing laws provision, and indeed if the Constitution were such that one looked in the abstract at whether a right declared in the Constitution had or had not been infringed, one would not get to the stage of saying that there has been any abrogation, abridgment or infringement of any of the relevant rights. And we submit there's an important difference between a law which in some respect inhibits a person from doing something within the scope of what might be said to be a right or freedom, and a law which infringes that right or that freedom, or abrogates it, or abolishes it, or abridges it. And we respectfully submit that our learned friend's case doesn't properly account for that distinction. But we also respectfully submit that the argument about the emergency powers in sections 7 to 12 of the Constitution doesn't take the appellant's case any further. It may well be right that what was done, in fact, under the 1940 ordinance could have been done at the time that it was done under the ordinance, could have been done under the powers in section 7 and following of the Constitution. But the fact that the minister chose to use the ordinance is not the legality of the fact that the minister chose to use the ordinance isn't affected by the existence of an alternative route of proceeding. So, in our respectful submission, there's nothing in that. And we finally submit that the proposition that these regulations, or the making of these regulations, was inconsistent with Section 1's provision in the Constitution that Trinidad and Tobago should be a sovereign democratic state, is not a sound proposition. My Lord, it seemed at one point in the submissions of my learned friend Mr. Ram Logan a few moments ago that a new point was being advanced in connection with the amendment, which is mentioned briefly in our case in a footnote of the ordinance, the 1940 ordinance, so as to substitute the minister in place of the Central Board of Health. That's not a point, as far as I can tell, which appears anywhere in our learned friend's case, and it's certainly not one I've come equipped to deal with. But as it turns out, because of the way the timings fall, we've got, I think, a day to think about further submissions. So, insofar as we need to say anything further about that, we'll think about that overnight, over 2 nights, and come back on Wednesday with our position in relation to that. My Lord, and of course I'm conscious that we've slipped from the existing timetable, so I'll need to cut my submissions down a bit, make up for the fact that, I presume, to make up for the fact that my learned friend rather overshot his timetable.
To do so. Mr. Knox has effectively used up his reply time that was allocated for this appeal, although it's up to him and Mr. Ram Logan how they use the time remaining to them in the Maharaj appeal.
Yes, right. Well, all the same, I'll do my best to keep as brief as I can on the basis that's always a good idea, whatever the circumstances, but I'm grateful for that. My Lord, I wanted to start just with a brief recap of the regulation, or rather of the ordinance itself. That's to be found at page 1307. And we've looked at this already, so I'm not going to spend very long on it, but just to emphasise a couple of aspects of it. I do submit that it's significant that if one looks at 105, which is, of course, the key section that we're concerned with, it authorises the board, then the minister now, to make regulations in general terms, but specifically in A, not only for the restraint, segregation and isolation of persons suffering from any dangerous infectious disease, but also the restraint, segregation and isolation of persons likely from exposure to infection to suffer from such disease. So it is already, on its face, a powerful instrument if it's brought into effect. And it also contains, at letter I, as we saw earlier, a very broad sweep-up clause, the doing of any such matter or thing as may appear advisable for preventing or checking such diseases. So it really couldn't be broader in its terms. And it's important in my submission to keep in mind that it's not suggested by the appellants that Section 105 is itself unconstitutional, or invalid in some way. And I respectfully submit that that's right. That's a perfectly sensible concession to have made. It's right not only because it's an existing law, but also, as I shall seek to show, because actually the entire structure of Sections 4 and 5 of the Trinidad and Tobago Constitution is such that it does refer to the state of the law as at the time of the Constitution's commencement, rather than declaring laws in the abstract. But I'll come back to that in a moment. So in my submission, it's important to keep in mind, as I say, that Section 105 is not itself said to be unconstitutional, nor is it said that the regulations that are under attack were ultra vires Section 105. So it's accepted that, but for the constitutional argument, it was perfectly proper for the minister to make the regulations that the minister made. The other provision in Section 105, in the ordinance rather, that I just wanted to show the board, or remind the board of briefly, because you were taken to it earlier, is what we find at 1310, which is in Section 132. That picks up what's said in 105.2, where it says that the provisions of Section 132 and 133 shall apply to all regulations made under this section. But 132, as the board will have seen, says that the regulations, once made, have the same effect and operation as if they were enacted by and formed part of this ordinance. So that the effect of making a regulation is effectively to incorporate within the body of the ordinance, or whatever it is that is said in the regulation.
But I think we were told it remains the case that these regulations aren't subject to affirmative or negative resolution. The minister makes them, they're published, that's that.
As far as I know, my Lord, my learned friend's right about that, yeah.
Yes.
So one turns then to the question, is it right, as our learned friends say, that the minister couldn't use this ordinance to make the regulations that we're concerned with on the grounds that, in some sense, they abridged or infringed rights under the Constitution? I'll come back in a bit, if I may, to the question, as it were, the second question. Do they, in fact, in a way, it might be said to be the first question, but I say we don't get to it because of the existing law provision. But I'll come back to the question of whether there was an abridgment or infringement of any of the freedoms declared under the Constitution shortly. But in my submission, the prior point, as I say, is actually what's the consequence of the rule that we're concerned with? I've called it, in the case of the rule, being intra vires the ordinance. And the answer in my submission is that actually that by itself rules out the possibility of the regulations being contrary to sections 4 and 5 of the Constitution. And I say that, as I say, not only because of the existing law clause, but because of the overall structure of the Constitution. And it's perhaps convenient for that submission just to have either in mind, or perhaps even better, in front of one, the structure of the Constitution. It's 1286 that we find sections 4 and 5 of the Constitution. And as we've already said in the case, and it's a trite point perhaps, but Section 4 speaks in pretty broad and abstract terms. It says that there have existed and shall continue to exist a whole series of first of all, rights and then freedoms, nearly all of which, perhaps all of which, in fact, are, by their terms, broad and can't sensibly be thought to be absolute rights. We've picked out some examples in the case. The absolute, the right to freedom of expression. It's trite that there's no absolute right to freedom of expression because you can't defame people, and there are certain sorts of speech which are forbidden. You can't incite crimes, and there's obviously room for debate about the boundaries of that and where they should be. And similarly, freedom of movement can't be absolute because you couldn't have absolute freedom of movement at the same time as the right to respect for the enjoyment of property. Otherwise, I could exercise my freedom of movement to come and sit in your front garden, which would infringe your rights. So, and one can think of lots of other similar examples right now. The point is, what one gets, as in many instruments, these general rights, and one has then to start discerning what does it actually mean in practice, in the concrete instance that one is confronted with. And the answer in respect of this Constitution, in my submission, is that one has to go back to the opening words of Section 4. It is hereby recognised and declared that in Trinidad and Tobago there have existed and shall continue to exist, without discrimination on various grounds, the following fundamental human rights and freedoms. So in the exercise of deciding what it is that the rights actually consist of in concrete terms, one is informed by what the position was as of the commencement of the Constitution. And that is not something that one gets on the basis of a doctrinal disposition towards originalism. It's simply a matter of looking at what the text itself declares, in my submission. And as we point out in our written case, the fact that this provision textually derives from the Canadian Bill of Rights 1960 leads us to one decision which is possibly of help, which is a decision of the Supreme Court of Canada under the Bill of Rights 1960, which in my submission underscores our point that when one looks for the concrete substance of these rights, one is looking to see what was the position in this case 1962, when the predecessor to this Constitution came into effect. And that's the Robertson and Rossitani case, which, my lord, you can find at 3842. I'll take it fairly briefly, but this was a case, as the headnote tells us, concerning trading on a Sunday, which was contrary to the Lord's Day Act of 1952. And the question was that act inconsistent with the Bill of Rights? The point being that the Lord's Day Act essentially laid down that you had to obey one particular religion's Sabbath. Well, if we look at the majority judgment, there was one dissent, but the majority judgment is what we need to look at, and that starts at page 3844. We can see over at 3845, section 1 of the Canadian Bill of 1960 is set out there, and one can see it really is absolutely verbatim, or rather Trinidad and Tobago took it absolutely verbatim from that instrument. At least in that respect. Section 1, your lordships will see, your lordship will see, recognised and declared that have existed and shall continue to exist. Interestingly, there is no equivalent of the existing laws clause, however, in the Bill of Rights, or there was no equivalent in the Bill of Rights 1960. Anyhow, the learned justice goes on at the bottom of that page to say, just after the extract, it to be noted at the outset that the Canadian Bill of Rights is not concerned with human rights and fundamental freedoms in any abstract sense, but rather with such rights and freedoms as they existed in Canada immediately before the statute was enacted. It is therefore the religious freedom then existing in this country that is safeguarded by the provisions of Section 2, which read in part as follows. And then Section 2 went on to say, which doesn't have any precise analogue, but essentially says that any act has to be read consistently with the Bill of Rights, except insofar as it expressly says that it's not to be. So that sets the task for the court. What is it the court is looking to find? Well, it's looking to see what was the position as regards the rights that people had in connection with religious freedom in Canada at the time that the Bill of Rights came into force. And the answer we find, I think, at page 1345. I'm sorry, no, we don't see it at 35, we see it 1348. Bottom of that page, the practical result of this law is said to be is to observe a day of rest, a purely secular and financial one. And then the second, perhaps the most important paragraph, is for the first main paragraph on the next page, on 3849. As has been indicated, legislation for the preservation of the sanctity of Sunday has existed in this country from the earliest times and has, at least since 1903, been regarded as a part of the criminal law in its widest sense. Historically, such legislation has never been considered as an interference with the kind of freedom of religion guaranteed by the Canadian Bill of Rights.
Didn't the Canadian court subsequently depart from this decision?
Yes, that's Big M, the Big M case, but I think you would say that that's because the charter,
that's right.
The charter was worded differently.
Yes, my lord, we make that point in our case. And I was going to look at, we might as well look at that case. That's at 1943.
Is that set up a religious purpose test, which the board has not followed in the recent cases that we handed down last week.
Oh, well, it's not a surprise then that some of this stuff is familiar to the board. I confess I have not had a chance to do more than read briefly what the board has said recently on that subject, but there'll come a time for that. But no, your Lordship's of course right that was departed from, but not by reference to saying that what was said about the Bill of Rights 1960 was wrong, but by reference to the Canadian Charter of Rights and Freedoms.
Well, we didn't have these words about there have existed and shall
that's right.
continue to exist. It was a different formulation.
That's right, and we can see go straight to it. It's 1991. Two-thirds of the way down the page, left-hand column. assuming one wants it in English, it's not necessary to reopen the issue of the meaning of freedom of religion under the Canadian Bill of Rights, because whatever the situation out of that document, it is certain that the Canadian Charter of Rights and Freedoms does not simply recognise and declare existing rights as they were circumscribed by legislation current at the time of the Charter's entrenchment. The language of the Charter is imperative. It avoids any reference to existing or continuing rights, but rather proclaims in the ringing terms of Section 2 that everyone has the following fundamental freedoms: a freedom of conscience and religion. I agree with the submission that the Charter is intended to set a standard upon which the present as well as future legislation is to be tested. So that's the important distinction. But of course, in the present case, we are concerned with a constitution which didn't have that, which hasn't been amended in that way, so as to bring in a general abstract right, which applies for the present as well as reflecting the historical position. So, in my respectful submission, even without the existing laws clause, the proper approach is to the Trinidad and Tobago Constitution is to say, well, what was the state of things as regards fundamental rights, as of the time when the Constitution came into force? It's complicated slightly here by the fact that we have two constitutions, one in 1962 at independence and another in 1976 when the form of government was changed to a republic, but the provisions are essentially the same. And so in my submission, the relevant date remains the day before the original independence constitution came into effect, and it's part of the inherent structure of the Constitution that the concrete essence, or the concrete substance of the rights is looked at as of that date. And that means, we respectfully submit, that one has to analyse, in a case like the present, well, what is the substance of the right? Well, the substance of the right here, which is contended for by the appellants, is essentially to be free of the minister's power to make regulations of the sort that he made under the 1940 ordinance. But if we're right, that one looks at the position as of the day before the Constitution came into force in 1962, the position was, well, the ordinance was there and it gave the minister power to do various things. And since it's accepted that on any ordinary principle of law, the minister had the power to make these regulations, the existence of that power is itself an existing law, and therefore one that is not affected by the coming into force of the Constitution. And in my submission, it's perfectly plain on the authorities that is the position that's been reached as regards Trinidad and Tobago itself. It's not merely by analogy with Canada. In fact, it doesn't appear, as far as I can see, that the Canadian jurisprudence was referred to, but if one looks at De Freitas, one finds clear statements to this effect, and I'll just take the board to that very briefly, if I may. That's 2448 in the authorities. This was one of the many cases about the death penalty. But in particular, the passage that we rely upon is the passage at internal page 244, which isn't very helpful for you. It's 2453. Towards the bottom of that page, between letters F and G, Chapter 1 of the Constitution of Trinidad and Tobago, like the corresponding Chapter 3 of the Constitution of Jamaica. And I should say, I think at this point the board is referring to the 62 Constitution, but the difference doesn't matter for present purposes. Proceeds on the presumption that the human rights and fundamental freedoms that are referred to in sections 1 and 2 are already secured to the people of Trinidad and Tobago by the law enforced there at the commencement of the Constitution. Section 3 debars the individual from asserting that anything done to him that is authorised by a law in force immediately before August 31st, 1962, abrogates, abridges or infringes any of the rights or freedoms recognised and declared in Section 1 or particularised in Section 2. Section 2 is not dealing with enacted or unwritten laws that were in force in Trinidad and Tobago before that date. What it does is to ensure that, subject to 3 exceptions, no future enactment of the Parliament, established by Chapter 4, shall in any way derogate from the rights and freedoms declared in Section 1. And then the exceptions are set out, which my learned friend went through earlier. Public emergency, acts passed by special majorities, and my friend didn't touch on it, but it's the other exception, I suppose, in theory, acts that actually amend the Constitution itself. So the clear position there in my submission is to that effect, that one is simply as concerned with what was the state of the law as of the time of the Constitution's enactment.
Well, I wonder. I mean, Lord Diplock isn't certainly saying in terms that fundamental rights were frozen as the law stood in 1962. And one can say in general terms that there was a right to, I don't know, security of one's property, for example, in the 18th century. Oh goodness me, what's the case called about
Entick and
Carrington? But obviously there have been developments in the law relating to searches of property with or without warrants since the 1760s, and one could say for the future that put in terms of a general right to security of property, that right has existed and will continue to exist, but that's not necessarily inconsistent with the precise boundaries of that right, or its modalities, if you like, altering from time to time.
Well, my lord, it may be that, I mean, clearly in the course of events, there may come, of course, situations that the courts haven't dealt with before, where the courts have then got to look at how to apply these general rights to a specific situation. That's a trite point about how human rights law develops, of course. And one can argue in those cases that the extent to which one is bound by the original understanding as of the words when they were set out in the instrument one was looking at. And one might further distinguish in that context between, for example, the character. This is some have argued one distinguishes between the character of a particular word and the specific content that it imports, and the content might change over time even if the character doesn't, for example. But whereas in the present case, the question is a specific one: does the minister have a power under a particular piece of legislation to do a certain thing? And the answer is, well, everyone agrees, yes, he did have that power as of the day before the Constitution came into force, because there is no challenge to the vires of the regulations. Therefore, it must be assumed that's what everyone's agreeing. Does the bringing into force of the Constitution change that situation? In our submission, there is a degree of, if one wants to use a slightly pejorative term, freezing of the rights, but that is the position, because that follows inevitably from the proposition that the rights in the Constitution are those ones which are recognised and declared by the Constitution. It's different if there is some. It's arguably different. It doesn't need to be decided for present purposes. It may be different. It doesn't damage my overall case, I submit, if in certain instances an entirely new factual situation arises which causes the court to have to grapple with a right in general terms. And what does family mean, for example?
Yes. Well, so leaving aside any question of the application of Section 6, on that approach, if there was a law, for example, prohibiting homosexual acts prior to 1962, then you would say that would remain in full force, notwithstanding what might be said in the Constitution, because the Constitution inherently doesn't go any further to protect rights of private life and intimate behaviour and so forth than it did than the law did in 1962.
Yes. Well, there are practical examples, one of which is currently before the board awaiting determination, which is the mandatory death penalty. Well,
there the argument was based on Section 6, or the equivalent of Section 6.
Yes, but it's essentially the same point. I mean, and of course the mandatory death penalty, which unless the board departs from its earlier decision, has been upheld by the board as being constitutional. Was
But
upheld.
it was existing law.
It was an existing law.
Yes, while these regulations are not.
Well, the regulations, the minister's power to make them was an existing law.
That's true.
That's
That's not quite the same thing.
Well, my lord, it's not quite.
Law is defined in the Constitution as including UK statutory instruments, and Section 6 says existing law means a law that has effect as part of the law of Trinidad and Tobago immediately before the commencement of this Constitution, and it's that is protected.
Yes.
There may be a power to make laws by regulation, but does it follow that that power protects such regulations as are made post-Constitution from the requirements to comply with fundamental rights?
Well, in my submission, my lord, it does, because one can't really. The argument that's made by the appellants is that these regulations, or this section, the rule, as I've called it, the 5 people rule, is for all purposes and in all circumstances void as being contrary to the Constitution. And one can't say that without really saying, in substance, well, the minister had no power to make the rule. That's the only basis on which one can say that it's void, in my submission, is, well, the minister didn't have the power to do it. But in order to say
Well, he may have
that,
had a statutory power to do it, but was it constitutional?
Well,
I mean, the question of varies, and the question of varies in general law and the constitutionality of the exercise of those powers are 2 separate questions.
Oh, well, I agree. I mean, it's accepted all around that, but for the constitutional element, the minister had the power to
Yes,
make
of course.
these regulations. But in saying, well, the minister couldn't make the regulations because of the Constitution, one is saying, therefore, well, the ordinance didn't give him the power. After the effect of the bringing of the Constitution coming into force is to take away from the ordinance the power that the minister had the day before the Constitution, so to make rules like this.
But why wouldn't you say the minister has the power, but it has to be exercised in line with the constitutional values as they now have been enacted post-1976?
Because that's not the structure of the Constitution, and that would, excuse me, that would cut across the existing laws clause. But De Freitas deals with an argument a bit like this.
Sorry, just before we move away from the existing laws clause,
Yeah.
I mean, Section 6.1 says nothing in Sections 4 and 5 shall invalidate an existing law, but no one's saying that Section 105 is invalidated. It remains valid law. It's just that the power under it has to be exercised in line with the Constitution.
Yes, but invalidate in this context is the analogue of, I think Matthew says this, is the analogue of Section 5. No law may abrogate, abridge or infringe or authorise the abrogation, abridgment or infringement of any of the rights or freedoms hereinbefore declared, recognised and declared. So it's, I mean, I'll supply the references perhaps on Wednesday if we need to, but the argument that, well, we're not really asking to invalidate it, just to sort of limit the extent to which it can be used is one I think that's been run before and has not found favour, and rightly not in my submission, because what one starts from is the argument, which I'll come on to say is a false premise anyway, but the argument is, well, this law abrogates, abridges or infringes, or more accurately, I would say the ordinance authorises on the face of it this particular abrogation, and that doesn't work because of Section 5. Well, Section 6 says, no, you can't do that in relation to something which is an existing law.
But don't the regulations under the ordinance have to be published in the Royal Gazette, and it's on publication that they then have the same effect? They have effect under Section 132, and presumably these were only published once they were made.
Well, yes, the regulations themselves didn't exist until they were passed and then put in the Gazette, but the underlying point is whether the minister's power to make them was an existing law or not. In my submission it was, because the minister's power to make them derives from the pre-constitution ordinance. Well, the analogous point in De Freitas is one that one can see it. One can see the argument, I think, at 2450. De Freitas was a death penalty case, as I may have mentioned, and if one looks at round about letter G.
Sorry, what page again?
Sorry, to 2450, my lady. The point in this case was that it couldn't be said that the death penalty itself, the mandatory death penalty, well, there couldn't be said the death penalty itself was contrary to the Constitution. But the argument was what one can see at letter G, Section 3.1 of the Constitution protects statute law and common law in force at the commencement of the Constitution. That's the existing laws clause, from being struck down as inconsistent with the recognised human rights and fundamental freedoms, but does not legitimise administrative acts done in furtherance of such protected legislation. If the administrative acts are unconstitutional, the administrative acts must pass the test of constitutionality. A distinction is to be drawn between the sentence passed by the court and the execution of that sentence.
Sorry, why isn't that passage against you?
That's Mr. Blom-Cooper's submission.
Oh, I see.
Which didn't succeed.
Which didn't succeed.
Right. Fair enough.
That's why I refer to it. You see it not succeeding at 2455. Where at letter C, the board says, just above letter C, it is in their lordships' view clear beyond all argument that the executive act of carrying out a sentence of death pronounced by a court of law is authorised by laws that were in force at the commencement of the Constitution. And in my submission, that entirely supports our argument that really this is about whether the minister had the power, and if once one accepts the minister had the power to make regulations under the ordinance as a matter of ordinary consideration of public law, then the fact that the instrument that gave the minister the power predates the Constitution precludes one from saying, well, in exercising the power, the minister has acted unconstitutionally. I mean, in a sense, if the board is the board is prepared to swallow the camel.
Power isn't the making of the regulations may be an executive act, but what they create is law, and the law is struck at by will be struck at by I think it's, let me check where it is in section 5. Yes, Section 5.1, I mean, the law would, on one view, abridge the rights in Section 4. It says no law can do that. So, yes, there may be, on this reasoning, executive acts carried out by the executive branch of government, which are authorised by pre-existing law. But you then come up against the fact that this executive act is the creation of law, and Section 5 says you can't abrogate or abridge.
And isn't the point being made, sorry, to come back to De Freitas by Lord Diplock, that there's, if you like, a direct transmission belt from the pre-existing law, which is the death penalty, order of the court, what else can the court do? It's got to apply the law. Act of the executive, it's got to carry out the order of the court.
Yeah.
So the existing law which is saved is the death penalty law, and that's given effect through the courts and then the Executive Act. But there's no such linkage here. There's nothing in Section 105 that says regulation should be made in any particular form. As my Lord says, the Section 105 gives a power to the Minister to make new laws. And then the question is, well, do they have to comply with the constitutional standards that exist at that time?
Well, I agree. The analogy isn't an absolutely absolutely direct one, but it comes back, in my submission, to the fundamental point that one can't sustain the challenge that's made by the appellants without saying that the reason that the minister couldn't do this was because the minister didn't have the power to do this. That's what it must come to, in my submission. And the question of whether the minister had the power to do it or not is to be reckoned by looking at the text of the 1940 ordinance. And once it's accepted the minister did have the power to do that, then anything which is done within, as it's sometimes been said in the cases, within the four corners of the statute that empowers the minister to do it, must by definition be constitutional. And one can't simply start by, I mean, on the premise, which as I say I don't accept, on the premise that these regulations themselves did abrogate, infringe or abridge rights and freedoms, one can't, in my submission, make that point about regulations made under a pre-existing law without necessarily, to some extent, invalidating and therefore contradicting Section 6 in respect of the pre-existing law. That's the short point in my submission. But in any event, as I submit, quite apart from Section 6, the whole structure of the Constitution, and we've set out various other authorities in the case, is such as to entrench in the Constitution, subject to the various modes for amendment, the law as it stood, the whole corpus of law as it stood, as of 1962, the day before the Constitution came into force, the first Constitution came into force. That being so, the question has to be, in my respectful submission, well, what would the answer to this challenge be, were the challenge being determined on that date? Well, just to complete, because I've jumped ahead slightly to go to that reference in De Freitas, but just to complete some of the references in that context, and this is just picking up really things that we've already said in our written case.
I'm sorry to interrupt you, Mr. Ray.
Yes.
It just occurs to me. I mean, I see your argument, and I'm not dismissive of it, but I wonder, is there not authoritative that a provision which derogates from constitutional rights, like the existing laws clause, is to be narrowly construed rather than broadly construed?
It's certainly been said, I mean, yes, it's certainly been said that provisions which derogate from the derogations to constitutional fundamental rights ought to be narrowly construed. But, of course, to approach it on the basis that, well, the Constitution sets out all of these rights and the existing laws clause is a derogation from it, therefore it should be narrowly construed, is, in my submission, to get one jump ahead, because actually the question is, what are the rights in the first place? One has to read the Constitution as a whole. I think we touched on this somewhere in our written case, but that's one of the reasons why I'm at pains to try to underscore the point that even without the existing laws clause, the structure of the Constitution, by virtue of the particular wording that was chosen, recognising and declaring the existence of, and declaring that there shall continue to exist certain abstract rights, is designed to ensure that the corpus of law that one is preserving against future encroachment is that which exists at that time.
Are you going to address us about the jurisprudence around Fisher and the development of fundamental rights in light of changing social circumstances and so on? Because I just wonder whether the have existed and shall continue to exist is a provision against backsliding, that you never get less than this. But that still leaves open the Fisher approach to constitutional rights, not the, I've forgotten the phrase, tabulated...
legal austerity of tabulated legalism.
Thank you. Trips off your tongue, it didn't off mine, but thank you. But you understand the point, that there's a lot of jurisprudence from the board explaining that rights do develop over time.
Well, my lord, that's right. I mean, I hadn't intended to make it a large part of my submissions because I'm not sure that's really how it's being put by the appellant. It's not as I understand it, being suggested that what they're seeking to vindicate are some rights which perhaps in the past people didn't recognise as fully as they should have done, and that changing social mores have
Sure, but it goes to your theory that we're somehow stuck with looking at these rights as they would have applied in 1976, and the point of my question is to question whether that is actually right.
Well, of course, I think it goes. I mean, I'll perhaps use the day's break we've got to reflect on that point and see if I can. Deal with
Fisher
it,
itself is a Bermuda case. I don't think there's the same wording in the Constitution as we've got here.
No.
But that's only one authority, and it may be there are other authorities which are more directly on point on our Constitution.
Yes, well, I'll look at that, and I of course I take the point that the content of a particular right can be seen to change over time, and family life being the obvious one, where one would have said in 1960 whether two people were part of the same family. Of course they're not, because they're both the same sex and they're not brother and sister, they're not two brothers, I mean, or whatever, whereas now it might be different. But that's a different exercise in my submission from the one that we're concerned with, which is simply to say, well, did the minister, granted that the minister unambiguously had this power as of the date the Constitution came into force, has the minister now lost that power? And if so, how? By what process? It's really for the appellants in my submission to demonstrate what it is that's caused the minister to lose that power. And simply to say, and I mean, this overlaps to some extent with my point about abridgment or infringement in general terms. But just to complete the authorities on the way in which one looks at the Constitution, because it's not just de Freitas that says it. We refer to Maharaj, which is 3190, which is Lord Diplock again. Is in the passage that I'm relying upon. And it's towards the bottom of the page, I think. Excuse me. Yeah, it's if one takes. Actually, it's from letter E onwards, forgive me, 3190. There's a reference back to de Freitas in section 1, the hunt of human rights and fundamental freedoms, which it is declared by the only words in that section that are capable of being enacting words shall continue to exist are those which are expressly recognised by the section to have existed in Trinidad and Tobago. It is necessary to examine the extent to which, in his exercise of and enjoyment of the rights and freedoms capable of falling within the broad descriptions in the section, the individual was entitled to protection or non-interference under the law, as it existed immediately before the Constitution came into effect. That is the extent of the protection or freedom from interference by the law that Section 2 provides, shall not be abrogated, abridged or infringed by any future law, except as provided by Section 4 or Section 5. What confines Section 2 to future laws that is made subject to the provisions of Section 3, that's the existing law clause, in view of the breadth of the language used in Section 1 to describe the fundamental rights and freedoms, detailed examination of all the laws in force in Trinidad and Tobago at the time the Constitution came into effect, including the common law, etc., might have revealed provisions which it could plausibly be argued contravene one or other of the rights or freedoms recognised and declared by Section 1. Section 3 eliminates the possibility of any argument along these lines. And then it goes back to quoting de Freitas. Section 3 does not legitimise, after the quote, for the purposes of Section 1, conduct which infringes any of the rights or freedoms there described and was not lawful under the pre-existing law. So that again, in my submission, underscores our point that one needs to look at the state of affairs just before the Constitution came into force and say, well, could one have made this complaint then? Since the answer to that question is no, because there was nothing restraining the minister from making the regulations that were made, it follows that the claim doesn't succeed in my submission. my Lord, one gets to the same point in a similar context in Matthew and the State. I can just perhaps take that brief by just give you the reference. It's in our case, but it's 3258. The well-known statement by Lord Hoffman in that case that Section 6 stands there protecting existing laws until such time as Parliament decides to change them. And Pandey and Gordon we refer to as well, which is 3588. Lord Nichols in that case described Section 6 as being there for good measure. It makes the point that Section 6 actually is not, it's not itself a provision that cuts down something that would otherwise be the case. And this goes to your Lordship's question earlier about the breadth of breadth of rights and the narrow construction of things that constrict the rights. Actually, Section 6 is just there for good measure to preclude Section 4 from having the effect of invalidating existing law.
Could you give me the page number?
Yes, of course. That was 3588.
Thank you.
And sorry, which paragraph are we looking at for that?
That was it's in our case. It's para 25. But it's para 23 in the in the decision. Let me just get that as well. So I think if the Lordship read para 23, that will cover the point, I think. That's the context in which I do submit that, as we say in the case, we're really adopting the way the board put it in Maharaj. The question is, what we need to examine is the extent to which, in his exercise and enjoyment of rights and freedoms capable of falling within the broad descriptions in the section, the individual was entitled to protection or non-interference under the law. And we respectfully submit that it's really back to front for the appellants to say, well, the starting point, as I think they say in their written case and said again earlier in my learned friend's oral submissions, to say the starting point is Section 5 of the Constitution. The starting point, in my submission, is to establish what is the concrete content in this context of these rights. And the answer is, well, they must necessarily be subject to any intra vires provision that's made under the 1940 ordinance. Because, as I say, one can't say that the minister had no power to make that law without saying that he wasn't granted it by the ordinance. And yet the ordinance does grant that power. That much is common ground, unless the Constitution gets in the way. And it's true, of course, that this argument turns to some extent upon the nature of the Trinidad and Tobago Constitution. And my learned friend and I both emphasise, for different reasons, the uniqueness of the Constitution in this regard. But we submit the important point is precisely that phraseology in Section 4. Rights have existed and shall continue to exist. The formulation that's adopted there. And in saying that gives rise to the structure that I say exists, one is not imposing upon the Constitution some predisposition towards originalism. One is simply recognising that's the way in which the Constitution has been drafted and has not been amended, and it's different from other constitutions that speak in much broader terms.
And as Lord Nichols acknowledges, that interpretation renders Section 6 strictly superfluous.
Yes. Which explains why the Canadian case that we saw was decided the way it was, in spite of the absence of any equivalent of Section 6 from the Canadian Bill of Rights of 1960. But in any event, my lord, my lady, my lords, my lady, we submit that it's not right anyhow to say that the rule that we're concerned with, abridged or infringed, any of the rights that are relied upon. And this is a proposition that, of course, if we're right about, gets us home regardless of what the board thinks about existing laws. Because in order to get the argument out of the starting gates, my learned friend has got to show there actually was an abridgment or infringement. And what's important in this context, I submit, is to distinguish clearly between that which merely interferes to some extent with your exercise of a freedom which is mentioned in the Constitution, and that which abridges your rights or infringes your rights. And the two are quite separate concepts, in my respectful submission, and there is, I submit, no support for the approach, either in the text or in the authorities, for the approach that our learned friends take, which depends upon saying that essentially, as I understood the argument, essentially almost any interference, other than perhaps one which is de minimis, with the exercise of rights under the Constitution is ipso facto an abrogation, abridgment or infringement, unless it is, in some sense, one that's already been done in other cases. It's traditional or it's well established. That in my submission, is to adopt an entirely unorthodox method to analysing this Constitution, which doesn't follow from its text or from general principles. My Lord, we respectfully submit that what the board said in Suraj was both entirely correct and entirely uncontroversial, ought to be entirely uncontroversial. And we say that actually Suraj didn't break any new ground. Lady Hale explaining in that case that the Equal Opportunity Act wasn't contrary to sections 4 and 5 of the Constitution, saying it can't be the case that every act of Parliament that impinges in any way upon the rights protected in sections 4 and 5 of the Constitution is for that reason alone unconstitutional. Wasn't making any grand statement about constitutional law or importing something into the Constitution that wasn't already there. We respectfully submit her ladyship was simply making the point, that not every constraint the law imposes on your right to do something is ipso facto an infringement or an abridgment or an abrogation.
What is your
of your
case as regards this impingement or this restriction under these regulations? You say that this is just a normal thing that you find everywhere, that there's a prohibition on people meeting in groups more than 5 people?
Well, of course, it's not a thing that one historically found everywhere. It's
so what's the point under Suraj then? How does this relate to what they were talking about in Suraj?
Well, in order to get home on the argument that what has been done here is to abrogate, abridge, or infringe rights, what one needs to do is that which I submit the appellants have not really done, which is to identify, first of all, to identify specifically what is the right one is concerned with. We've heard about freedom of movement, freedom of assembly. In my submission, one needs, first of all, to look specifically at what the right is, and then one needs to look at the extent to which there is actually an infringement, an interference, rather, and to ask, well, does that constitute an infringement? And what one finds in my submission, and the Dolan case in England and Wales is helpful in that regard, I submit. What one finds actually is, first of all, one needs to set aside some of the claimed rights that are said, some of the rights that are said to be relevant, because we say they're simply not. Freedom of movement is not affected at all by these rules. The rule didn't prevent you from moving anywhere you liked in Trinidad and Tobago, subject to the pre-existing laws about, no doubt, not going into other people's property and so on and so forth. So one needs to identify specifically what it was that was interfered with, and then one has to ask, looking at the law in its totality, can it be said, and this was the way it was put in Dolan, and I'll try and develop this a bit more systematically in a minute, but to answer your ladyship's question, what one needs to say, well, can it be said that this law operates incompatibly with those rights in all or almost all circumstances? That was the way it was put by the Court of Appeal in Dolan. And
so you say we could just read across from Dolan even though that's in the context of a constitutional framework which is very different from the Trinidad and Tobago constitutional framework?
Well, it's not relevantly different to the extent that it alters the outcome, in my respectful submission. Of course, I accept that the constitutional setup is different in some respects, but what the court was, if we're at this stage in the argument, what we're concerned with is was there an infringement, not was there some degree of interference with the ability to exercise the relevant right, but was there an infringement of the relevant right? And our case is that, first of all, one can set aside freedom of movement because this rule did nothing to infringe freedom, to interfere with freedom of movement. One can set aside, I submit, also freedom of association with others because it didn't prevent you from associating with others. The reason for that, and we mentioned this in the case, is because freedom of association is concerned with your right to form associations with other people, not necessarily in physical terms. As freedom of association carried on throughout the pandemic in all jurisdictions that had restrictions, including in England and Wales and the rest of the United Kingdom, where there was a very stringent lockdown, but associations carried on meeting. All the various legal associations that probably most people in this courtroom who are lawyers are members of carried on meeting, albeit they had to do it over the internet rather than in more congenial ways. So really one is concerned with the only right that's left, which is freedom of assembly. And there we accept that there was an infringement, there was an interference, I should say, with the right to freedom of assembly.
When does an interference become an abridgment?
Well, that's the critical issue in the case, which is, in my learned friend's way of looking at it, is dealt with by saying, well, because this was unprecedented, or non-traditional, or extraordinary, or unusual.
You accept that if there'd been no pandemic, it would have been unconstitutional for the government of Trinidad and Tobago simply to say, we don't really like people all meeting up together. We're going to say nobody can meet in groups of more than 5 people because we're a bit worried about what you're all getting up to. Would that be an infringement of the right of assembly if there were no external circumstances?
Well, probably, yes. I mean, one would have to look at, it depends on how extreme the hypothetical example is.
I mean, you hesitated.
Well, because I think your ladyship said at the end there were no external circumstances. So plainly, if it were merely caprice on the part of the government, of course it would be impossible. It would be impossible to justify that at common law, never mind under the Constitution. But what we're concerned with is a specific statutory power which is conferred for the purposes of public health in circumstances where there is no dispute that the government had valid reasons based on the medical and epidemiological advice it was getting at the time, this was the right thing to do. I mean, whether it was the right thing to do or not, no doubt people will be debating for decades to come, but looking at it at the point at which the law was made, the regulations were made under the pre-existing right to make them, that was the state of affairs. And the question was, in those circumstances, is what has been done such as to go so far as to constitute not merely an interference with the ability to assemble with other people, but an abrogation or an infringement of people's rights. And we...
Again, you come back again and again to abrogation and infringement, and you miss out the word abridgment. I mean, what is the difference between a serious interference with a right and an abridgment of that right?
Well,
I don't wish to indulge in tabulated legalism, I hasten to add, but why has this Constitution had that included? Why has it included that provision?
Well, they're all synonyms. All 3 of them: abrogate, abridge, or infringe are the words we should stick to that Section 5 uses. They're all synonyms for breach of the right, in my estimation. They're all things which will constitute a breach of the right.
They're saying what is a breach of the right. Yeah. It is a breach of the right to abrogate, infringe, or
Well, I'm not sure that's, if one means by abrogate, abridge or infringe any constraint on the person's ability to do something in the context of which might be related to...
No, I think everyone agrees that we're not going so far. The question is, how far are we going?
Well, ultimately, it's like all of these questions, it's a matter of fact and degree, and the court will tell us ultimately whether it thinks the line has been crossed or not. But the reason...
Isn't that the point, whether it is for the court or whether it's for the Parliament to decide whether it's right or not?
In my submission, it must be in the first instance for the court. Otherwise, you end up in a state of affairs where there's an unruly law by which anything which does to any extent interfere with somebody's right to, or somebody's ability to exercise their freedoms they would otherwise have, might be said to be an abrogation, abridgment or infringement, and it's up to Parliament to decide. That doesn't fit within the scheme of the Constitution. It creates the additional problem that it's completely inconsistent depending on whether it's legislation one's talking about or executive action. This is to pick up the point that Lord Sales was making to a learned friend in the course of his submissions. One would surely accept in the context of executive action that it's a matter for the courts.
I wonder if you're thinking about the language. To infringe is, I would have thought, a synonym of to violate. Mm-hmm. But if you abridge or abrogate the right, then there's no violation of the right, because the right itself has been cut back in such a way that the conduct no longer violates it. So perhaps it's talking about the ways in which effectively the right could be defeated. I mean, either you violate it or you cut it back partially or totally, so that the same protection no longer exists.
That might be.
I suppose the wording must come from somewhere. It may be something else that comes.
Yes, well, my learned friend points out it comes from Canada in the first instance. I mean, that's where they got it from.
Right. Yeah.
Perhaps that can be the subject of further researches.
Now, I see the time.
Yes.
Mr. Rowe. Is this a convenient moment?
Yes, by all means.
Very well.
In my haste, I forgot to give a reference to one important statute, mercifully short.
Yes.
Which was the Emergency Powers Act 1947, or Ordinance, Emergency Powers Ordinance 1947, which contained effectively emergency powers in the case of imminent threat to the country from an internal source. And the reference is, I say no more about it, is at Supplementary Bundle 2, page 2. It goes on to page 4. I apologise, I should have mentioned
Not at all. No, thank you for that, Mr. Knox. Very well. Well, if there's nothing else, then we'll adjourn now and resume at 10:30 on Wednesday morning.